Hi, everyone. Harry here to talk about the latest move in what's become quickly a cause célèbre case involving state court judge Hannah Dugan in Wisconsin and the federal charges that now have been lodged against her for supposedly trying to impede the federal effort to arrest on immigration charges a man who was a defendant in her courtroom. So she's been arraigned on the charges. She said she pleaded not guilty. There was a big crowd in support. And this is probably going to stay that way for every juncture in the case. She left the courtroom quickly without saying anything. However, she filed her motion to dismiss the indictment on grounds of judicial immunity. And the motion itself really sets out the competing narratives that the federal government has and is going to have to try to prove beyond a reasonable doubt. And that she says, first and foremost, she says, I've got judicial immunity here. And why? I am policing and just taking care of overseeing my courtroom. That's what state judges do officially. Some people, I'll say, go out this exit. Some people that. I do not have to encounter and countenance a chaos in my courtroom. I want to keep things running well. That's my official job. And guess what? There is immunity dating back to the common law for judges doing their official job. The Congress has never abrogated that state court judicial immunity. So you can't even indict me because immunity means I'm entitled not even to stand trial. And certainly you can't convict me. But the overall theme that the motion sounds, I think, is going to be important and basically is going to come as a rude surprise to Attorney General Pam Bondi. She was a state attorney general, and she should see this, but they haven't. This really does set up a federal versus state authority situation, and the Supreme Court has been very strong in a series of cases from about 20 years ago, really elevating the dignitary, legal, practical interests of the state. You can't just kind of go around and use them as accomplices to effectuate federal policy. So she points to cases that said, here you're trying to use us and actually leverage, and it's really true. I mean, we know they like to arrest in state court because the people they're arresting have gone through a magnetometer, and so they're not armed. What is that but forcing the state to sort of be your partner? But that's in violation of a series of cases involving the 10th Amendment. We also, a very important part about immunity is, and we've seen this again and again on the federal side, and we've got what's good for the goose is good for the gander, or what's good for the feds are good for the states. Subjective intent doesn't matter. They could try to have proof that what she wanted to do was keep Ruiz, the defendant in her courtroom, from being caught by the feds. It doesn't matter. What matters is whether her acts were official, part of her duties, and if they were, they're not supposed to be coming in and interfering. And so she tells the account that I've been anticipating and told you, it seemed to me the complaint absolutely gave rise to, and at least a sort of 50-50 situation, which by definition means they shouldn't be able to convict her beyond a reasonable doubt. On her version, she's there. She gets caught by surprise. She wants to keep control over her courtroom. Moreover, and really importantly, and I've made this supposition, but now her motion confirms it. She either there's a deputy who's going to be subject to fierce cross-examination, I think, who says she ordered Ruiz and lawyer out the door. She says she told them use this exit and escort, but it really doesn't add up to much, because what we know now from her motion is the door that Ruiz exited back into the hall a few feet from where the entrance to her courthouse, which is to her courtroom, which is where they wanted to make the arrest. So this supposed big harboring idea is to tell the defendant, go out this door, where he would immediately encounter, and did immediately encounter, whole 6-person force, except they were talking with the chief judge to try to get the signal straight, which they hadn't done in advance. Instead, but there was one there who'd been left, immediately saw the defendant, not the defendant, Ruiz, the person they wanted to arrest, went down the elevator with them. The other 5 joined them. They went to arrest him. He ran a short distance. It's the distance of the building, and he was then arrested. So this is a really big fact, it seems to me. Where she told him to exit was a few feet from where they wanted to make the arrest in front of the courtroom door. There was no reasonable prospect that somehow she was, taking him under a tunnel and shepherding him to freedom. Quite the opposite. So what's the difference between the entrance and the side door? It seems most plausibly to me, and certainly equally plausibly, she just didn't want to have this chaos and ruckus in her courtroom. This is her courtroom where she does her official duties. And by the way, since that's what she was doing, the case should be dismissed. So that's the first shot across the bow for a judge to the federal judge who's overseeing this case now in the Eastern District of Wisconsin. And man, what a debacle it would be if the feds lose on this ground. But it'll be very interesting to see what they have to say. At a minimum, though, so first, we have these very interesting legal issues, and they're sort of turnabout is fair play, feds. You're trying to commandeer, is the legal term, our legal apparatus to do your bidding. That's not how it works. It's exactly how it doesn't work, as the Supreme Court has said. But we've also set up the clear factual accounts and how they will differ if there is a trial, and the court set a trial date for the fall. That has a tendency to slip, but that's when it's right now scheduled for. But we're going to first have these motions, including this one that she filed today, and it's going to be a very sympathetic defendant, state court judge, and probably others saying, I wanted to control my courtroom. That's why I did these things. Of course, I wasn't trying to make them escape federal custody. I sent them right out into their arms. So both on legal grounds and on factual grounds, this motion strikes me as a really strong pushback from the judge. And I think that it's by no means often the first motions defendants make in a criminal case are kind of make weight, they're going to lose, just sort of boilerplate. Not this one. This is some serious issue, and it gets to the heart of what's going on across the country as the federal government is trying to enlist, voluntarily or not, states, including those that have different policies. This is what was going on in New York City with Adams, right? They have different policies, and they want to say, we can follow our policies as long as we're not really gumming up your works. And we'll see how the feds answer, both on the law, but on the facts. It's it seems to me, as I said initially, you're supposed to write out a prosecution memo. Presumably somebody did this before you bring charges, and you really need to document how are you going to prove every element beyond a reasonable doubt. And I don't see how a professional assistant U.S. attorney, much less a supervisor of that professional, would have reached the conclusion that this is a case where conviction is probable as you have to. So I think the feds have stepped in it and are kind of in a bit of quicksand, going deeper and deeper. And it is inevitable is too strong a word. Things can happen. But I think they are really stuck with a loser of a case that's going to be a great embarrassment to them when either on motion or by a jury, Judge Dugan is exonerated. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.